That certainly does play into what types of structures we need to set up, how sophisticated the asset protection work that we are doing needs to be. The next question is, who is the creditor that will be pursuing our client? Again, sounds like a simplistic question. Well, I know who the creditor is. My client just defaulted on the loan from Citibank, and it will be Citibank pursuing our client. Well, again, not that simple. Creditors come in different shapes and sizes. Some creditors are aggressive and intelligent. Other creditors are lazy and maybe stupid, maybe not that well informed about collection laws. So, for example, a bank usually makes for a very aggressive and a very intelligent creditor. Banks will have in-house attorneys who do nothing but collect for them. Banks may use a private law firm to do their collection work. And banks tend to be aggressive about collecting their debts. It's just the way it is. And in this economy, over the past, about 18 months or so, the bulk of the clients that we have been seeing are people that are being pursued by banks. These are people who, let's say, bought real estate in Florida, and now this real estate is upside down. And Florida is one of the states that allows the lender to get a deficiency judgment, meaning once the property is foreclosed upon, whatever is left owing on that debt, the lender can pursue the borrower and pursue the borrower's assets. So, for example, we have a lot of clients here in California who bought real estate in Florida. Real estate is upside down. They want to walk away from that real estate, but they're afraid the bank will come after them on any amount of that deficiency. In the past year, I've represented probably 60, if not more, real estate developers. As you probably are well aware, this has not been a good time to be a real estate developer. And if you're a real estate developer, how does it usually work? You have a legal entity through which you will pursue your project. The entity borrows the money from a bank, but usually someone has to sign a personal guarantee. And these people in this economy become our clients because they're now defaulting on those loans. And then they remember they have personal guarantees and that all of their assets are exposed to the bank. So when we are working against a creditor like a bank, the planning that we do has to be a lot more sophisticated, a lot more aggressive, more robust than in other cases. If the creditor is, let's say, a plaintiff's attorney, so it's a plaintiff's attorney who is working on a contingency basis, and let's say that this plaintiff's attorney is an absolute genius in getting a judgment and winning that lawsuit. Well, even if that is the case, very few plaintiff's attorneys are knowledgeable about collection laws, meaning they know how to get a judgment. They get that piece of paper from the court that says that, our client owes money to their client. But they do not know how to convert that piece of paper into our client's assets. And we are going to take that lack of knowledge into account, and maybe the structures that we set up will be a lot simpler in that case. Maybe we simply will aim to move the assets off the client's balance sheet and be done with it. The most important factor is the type of the asset that we are looking to protect, meaning what are the assets that our client owns. Clients own residences, fantastic. We need to look at how much equity is in the residence. What are the ways to protect the residence? And we'll talk about that at the very end of the 3 hours about the different ways to protect a personal residence. Clients owns a bank account. Well, there are different structures that we use to protect bank accounts, all kinds of liquid assets, investment accounts. A client has a business and income-producing real estate. So for these different types of assets, there are different types of structures available. Okay, so the important point here is that in asset protection planning, there is no silver bullet structure. There is no one structure that works equally well across the board for every single client, for every single type of asset. There's just no such thing. There is a multitude of structures, several dozen different structures. And we need to know which structure we are going to use in this particular case. How do we determine that? Well, again, you go through the questions on the slide, you analyze them, and it gives you an idea, how much risk is the client exposed to, types of assets he has, how aggressively will he be pursued, and so forth. And that helps us determine how far to take this asset protection planning. Certain types of assets are protected under state law by the various exemptions. So, for example, if you live, let's say, in Florida, Florida Constitution provides for a homestead exemption, meaning that the equity in your home is not reachable by creditors. And in Florida, this homestead amount is unlimited. You can have a $20 million residence in South Beach, and it's not reachable by claims of your creditors. There's actually a bankruptcy court case from about 10, 15 years ago where this business owner who was going to file for personal bankruptcy moved to Florida, bought a house in Florida, ripped out all the railings and the fixtures and the faucets, and replaced them with ones made out of pure gold. Okay, a real case. Put like $6 or $7 million of gold into the house. Filed for bankruptcy. The judge says it's all exempt because under Florida law, we have the unlimited homestead exemption. In states like, for example, California, where I'm standing right now, the homestead exemption is very small. For a single person, it's $50,000, and it may go as high as $150,000 for someone who's over 65. And it varies, obviously, from state to state. In Hawaii, it's like super low. In Nevada, it's a little bit higher. In Texas and Kansas, in addition to Florida, it may be an unlimited homestead exemption, depending on the size and the acreage of your property. There are all kinds of other assets that are exempt, either fully or to some extent, from claims of creditors, like, for example, retirement plans in a lot of states, or at least some types of retirement plans, are exempt from claims of creditors. Some states exempt life insurance policies, the cash value in the policies, from claims of creditors. Some states only exempt term life insurance policies. So we need to know what the exemptions are in the state where the client is located to see how far those exemptions can take us. So we go to the next slide. Before we get into the actual asset protection planning, we need to know what is it that the bad guys, the creditors, can do to get to our clients' assets. You really have to know that before you can figure out what you need to do to prevent that from happening. So very briefly on this slide, because this is not a presentation on collections, I'm going to skip to bullet point number 3, prejudgment attachment. The general rule in debtor-creditor law is that before someone can come after your assets, they have to have a judgment against you. Meaning, let's say you owe money to American Express. You know, you're charging things to your credit card, you're not making the payments, you owe money to Amex. Can American Express, you know, when they see that you're not paying, simply say, hey, you owe us money, so we're going to take your car, or we're going to put a lien on your residence? They cannot do that. Before Amex will be able to do that, they will need to file a lawsuit against you for not making payments on your credit card. Once they file a lawsuit, they will likely get a judgment. Once they have the judgment, that is when they can go after your client's assets. They have to have a judgment. There is one exception to that rule. That exception is what appears on the slide as prejudgment attachment. And prejudgment attachment, as the name implies, is a remedy that creditors have that allows them to basically place a lien on the debtor's assets before they get a judgment. They file a lawsuit, they get this prejudgment attachment, put the lien in place, and then they go on with the lawsuit and eventually get the judgment. The prejudgment attachment is designed to make sure that by the time the lawsuit is concluded, there are still assets there available for a creditor to collect against. Prejudgment attachment is available in fairly limited number of cases. It has to be in the context of a business lawsuit, not some sort of a personal lawsuit or a tort action. It has to be a business lawsuit. And the amount of damages has to be reasonably ascertainable. So, for example, let's say you are leasing office space and your rent payments, I don't know, $5,000 a month, and you miss 2 payments. The landlord files a lawsuit. Well, this is a lawsuit arising in a business setting, right? You're leasing office space, not your personal home or an apartment. And the damages are very easily ascertainable. You missed 2 payments, so we know exactly what the landlord's damages are. It's a perfect example of a plaintiff creditor who would be able to get a prejudgment attachment. In this economy, prejudgment attachments are very, very frequent, and you need to be well aware of them. Because what are the types of lawsuits that we see in the current economic climate? We see lenders pursue people who, you know, default on their loans, people who default on their personal guarantees. We see tenants who breach their lease agreements. All of those are business-related lawsuits, and in all of them